The False Claims Act is the federal law which imposes liability on persons or companies who defraud federal government programs. It is the government's primary litigation tool in combating fraud against the government. The False Claims Act contains a key term provision which allows an individual not related with the government to file a lawsuit on behalf of the government. These individuals are commonly known as whistleblowers. The individual who blows the whistle on a successful case may be entitled to up to 30% of the recovery in the case. A person or a company that submits a false claim to the government or causes a false claim to be submitted to the government can be liable under the False Claims Act. The best way to describe what a false claims is to provide examples. One instance is an individual goes into a physician and receives a checkup. The physician provides the checkup, but in addition to billing Medicaid or Medicare for the checkup, the physician bills the Medicaid or Medicare for a checkup and an x-ray. Another example we've seen recently is with hospice care. Companies will go in, say the individual qualifies for hospice and start providing the services. However, these individuals have not met the requirements to be at the stage of hospice care. These services are being provided, but the services are not medically necessary. Therefore, the claims submitted to the government on these services are fraudulent. Another example of a fraudulent claim is where a company has contracted with the Department of Transportation to build the guardrails for the highways. The contract called for a certain grade steel to be used. However, the company used a lower grade steel, which did not meet to the contract terms. Therefore, the guardrails were not as safe and effective as they were required to be by the contract. All of the claims the company submitted to be paid for these services constitute a false claim under the Federal False Claims Act. The False Claims Act has a key term provisions which allows individuals to file a claim on behalf of the government. Generally, the individuals that file these claims are employees who have inside information that the company is submitting false claims to the government. The individual must have knowledge of the false claim and be able to provide their attorney evidence of the false claims and describe what laws are being violated or what contract terms are being violated. A whistleblower lawsuit must be filed within the applicable statute of limitations. The whistleblower must file their lawsuit no later than 6 years of the violation. The False Claims Act contains provisions which protect whistleblowers from adverse employment action or discrimination. A retaliatory discharge claim may be filed on behalf of a whistleblower if the employee discriminates, fires, demotes, or harasses the whistleblower. A whistleblower would be entitled to up to 2 times the back pay and be reinstated to their original position. The retaliatory discharge claim must be filed within 3 years of the discriminatory act. A whistleblower should contact a whistleblower lawyer in order to have their rights explained to them. It is important that you choose an attorney who is experienced in whistleblower law. There are many provisions that must be met before a whistleblower claim can be brought. Additionally, an experienced whistleblower attorney can properly advise you as to whether you have a potential claim and whether you have sufficient evidence to bring a claim.